74. If before argument begins, counsel on either side applies to the court for extension of the time prescribed for argument and states his place or on oath of discretion of the court that he cannot do the case justice within the time prescribed, that will require for that purpose additional time, stating how much time will be necessary, the court shall grant such extension of time as may be reasonable and proper.
Not to exceed 30 minutes.
Not to exceed 30 minutes. That's the rule.
An additional 30 minutes.
Absolutely.
Right.
So the most you can give any party is an additional 30 minutes in a misdemeanor case. I agree with that. What our position is, Your Honor, is you cannot give me, nor can you give the state, any addition of time until a party applies for it. That nowhere in these two statutes does it say that the court can sua sponte decide. And I certainly appreciate what you're saying, is this is a longer trial than most, that we've had a number of witnesses. But, Your Honor, where in this these provisions does it allow this rule to be applied in the absence of a party applying to the court for it, stating as the statute requires, and in addition doing it prior to argument begins? On those grounds, Judge, we ask you to deny both the state and the defense anything beyond the rules, as neither party applied prior to argument beginning and the court made no finding prior to argument beginning that there could be an extension of time.
Okay. And I understand your argument. As I said, I probably should discuss this with the parties, and my assumption was that we were going to go longer than the 30 minutes given the time. But I understand your argument, I understand your objecting, but I am going to give each side 40 minutes. In case the amount of evidence and the time we've taken with this case clearly dictates it. And you're right, the state probably should have asked for it. But the overriding issue for me always is allowing all sides to have the best opportunity to present their best case. And so based on that, I'm going to permit each side to have 40 minutes. So you've got 10 more minutes. I don't care how you plan to use it, and he's got 40 as well. Let's get yours out.
All right, so jury.
Okay, let's continue.
All right, so 6 out of 6 on the HGM. The next round was a divided attention test, indicating that somebody can do both, listen to instructions, as well as carry out instructions. Divided attention is something that you do when you drive every single day. And this, ladies and gentlemen, is a relevant portion you need to pay attention to. The video that you saw, that one leg, the walk and turn. 4 out of 8 clues on the walk and turn. You watch that video. Mr. Budenholzer leaning over, starting to walk, stepping off line, turning incorrectly, just turns around, not in the way that it was demonstrated. These are all things that he is able to do. These are not hard tasks. Walking, hands by your side, turning. 4 out of 8 clues. Remember what that looked like. This is someone who would have potentially gotten back in a car and driven through the streets of Atlanta. The one leg stand. He has a foot injury, but you know what? He stands on the other foot. Falls over. When he's reminded what the instructions are, look at your foot, even worse. He wasn't following instructions. He had his arms out. Think about what you saw in that video. Think about how he fell over. And this is someone who potentially could have gotten back in a car and driven through the streets of Atlanta. Then there was the preliminary breath test. 1 glass of wine, didn't feel impaired, knew he wasn't impaired, knew he wasn't drunk, refused. State's test. 1 glass of wine, knew he wasn't drunk, knew he wasn't impaired, refused. The judge will instruct you that you can make an inference on this
should help us all along in determining what took place. August 27th, the night before, Mr. Budenholzer valets his car at the Lowe's Hotel. Remember, he had just arrived here at the end of July, roughly around the time that the trooper had a couple weeks after he had graduated from trooper school. And he turned his car in at night with a valet, and he picked up his car the next morning. During the day, he and Danny Ferry, traveled to various gyms that afternoon to find a training camp site. Both of them testified to that. Approximately 9:15 at the conclusion of the day, they arrived at Local 3, the restaurant, for dinner. Budenholzer had a full meal, finishes one glass of wine, but not a second glass of wine. And then 10:15 to 10:20 after dinner, Mr. Ferry takes Budenholzer back to his car in a well-lit parking lot. That time, 10:15 to 10:20, Ferry drops off Budenholzer at his car. Budenholzer drives from West Buckhead to Midtown, and we learn that he left the well-lit parking lot, one intersection, well-lit intersection. And folks, if you have experience in driving on 75 or 85 through downtown, I would ask you this: what do you consider to be among the most well-lit areas of the city? I would say it is 75, 85 downtown. Now, I'm not making excuses and say it was okay for Mr. Budenholzer to drive through that area. But consider what you heard, the testimony from the valet about why his lights were turned off. Consider what you saw for yourself about what his dashboard looks like. Consider that no one flashed their lights at him, and that the entirety he was driving through a well-lit area. At 10:43, I'm sorry, let me back up. At 10:30 p.m., he stopped by Trooper Nels for no taillights. At 10:43, that's when he's asked to submit to the portable breath test. And despite what Ms. Batra says is he refused, he said no. And despite what Trooper Nelms said, once you got to listen to the video and I got to question Trooper Nelms, you learned that that's not exactly what took place. What took place is that Coach Budenholzer said, is there someone I can call to ask if I'm supposed to do this? He's new to the state of Georgia. Whether you agree or disagree with the experience he had years ago in the context of working with the San Antonio Spurs, he was told, and if you remember, at least one juror on the panel was told, don't submit to a breath test. Reasons why: inaccuracies, problems with it. It's not a one-to-one reading. You know, BAC, blood alcohol concentration, a breath test is different than a blood test. It doesn't really matter. But he had questions. Not because he was concealing his alcohol level, but because you learned he had never been through this before and he didn't know what to do. And folks, is there anything wrong with, if you're in a situation like this, asking for help, asking to talk to somebody who might be able to shed some light on what my rights and obligations are? Okay? At 11:11, I'm sorry, let's back up. He's asked someone to take a test. At 11:11, he's already been placed under arrest, and he's in the back of the patrol car, and he asked to speak to his wife, asked her to call Danny Ferry. And in just a moment, I would like for you to listen to that conversation. Okay? At 11:40, Trooper Nelms arrived at the City of Atlanta jail and turned Budenholzer over to deputies. Pay attention to those times. I certainly did, and I want you to consider them. Because if they arrived at the jail at 11:40, and that's Trooper Nelms' own testimony, what time did we learn from Mr. Budenholzer and from Danny Ferry that the first phone call Mr. Budenholzer was able to make from the jail? 11:49. Budenholzer speaks to Danny Ferry, asks the jail officer if he can take a test, and no efforts made to contact Trooper Nelms. 12:13 a.m. Why is that time important? Because we presented the unit history, the log of where Trooper Nelms was when he called in that he had stopped the vehicle, when he called in the arrest, when he called in the arrival at the jail, when he called in he was leaving at the jail. What did we learn from that document? That at 12:13, Trooper Nelms left the jail. He told us he wasn't sure if he was inside the jail or in his car, in the Sally Port, or outside the jail, but he was still there. And at 12:13 a.m., he was still at the jail. We already had Mr. Budenholzer asking if he could take that breath or blood test. I think his words were any test. At 1:02, sometime later, Danny Ferry was able to connect with me. I'm the Mike Hawkins you heard about. You all knew that. And the purpose of that call, you learned, was apparently nobody was responding to Coach Budenholzer's request. We learned from Trooper Nelms that he heard from his immediate supervisor, a Corporal Mike Land, and then from his post commander, Sergeant John Cronin, that a request was being made and why wasn't anything being done, or words to that effect, and he needed to go back down to the jail. And that's what happened 2 hours and 10 minutes later. Bear in mind, the testimony of Mr. Ferry and his phone records, the testimony of Mr. Budenholzer about these calls is unrebutted, meaning the state presented no evidence to show that that was inaccurate or untrue. When you consider that, I think what you see is a pattern. While Mr. Budenholzer's in the jail, he told the trooper twice on the street when he was confronted with being asked to take a breath test, "I don't know what to do, can I call somebody?" He got the opportunity to call somebody. And when he was able to call somebody, what happened? A series of events happened where he requested and no test was given to him. Okay? 126, third call from Mr. Budenholzer. 201, call from Budenholzer to Dane Ferry. 202, that's when the conference call was. 229, that much later is when Nelms returned to the jail with the blood kit. And I want to talk about that in just a minute. Okay? Oh, sorry. Now that we have a timeline, I want to go over some of the specifics of the evidence in the case. Okay? And again, I'm going to go over some of these in detail, and I'll do my best to move through them. Okay? 3 witnesses, 3 testified about the meal that was had that night. Okay? You would have to disbelieve each of them individually and all of them together. Again, there was no cross-examination or rebuttal that demonstrated that any drinks were had anywhere else that day, that they sat at the bar as the prosecutor suggested. What happened was, and the waiter acknowledged this, and both Mr. Ferry and Mr. Budenholzer acknowledged this, is that Danny Ferry and Mike Budenholzer came in and the others were already seated. Okay? Now, I called Danny Cavanaugh a sleepy waiter. You remember him? He had the tattooed arms and the beard, and he just kind of looked and acted like he just woke up, probably because he just woken up. He's a guy that lives a nighttime lifestyle. Okay? But I submit to you that if he didn't know the answer, he said, "I don't remember. This was a long time ago." Okay? But he did remember because an investigator had come and visited with him shortly after and asked him, "Can you produce the receipt from a party of 5 where Danny Ferry was the person who paid the check?" And we learned then that he knew who Danny Ferry was because he was a Cleveland Cavaliers fan and recognized him. Okay? So there is what we learned about that. And you bet we made a big deal out of this. You bet that we did our best, we meaning the defense in this case, to bring you as much of the truth as we could. The state brought you one witness who had been on the job for 3 weeks, who didn't consult with other troopers and didn't consult with his supervisors. And I can establish in detail for you by his own testimony why that's important and exactly what he said. Now, the state wants to make a big deal out of the notion that there was more than just one glass of Appleshine, this Pinot Noir. And I asked Mr. Budenholzer, "You told the trooper you had only one glass of wine. Why did you do that when you had more?" And he said, "I did not have a second glass of wine. I didn't finish it." And you can do what you want with that. He was nervous. Ms. Batras wants to say he was lying. Perhaps he was minimizing. But he took this stand just as any other witness. And he swore under oath to tell the truth. And he told you. He didn't have to do that. A defendant in a criminal case does not have to testify. But Mr. Budenholzer wanted to testify, and he wanted to testify truthfully. And the truth is, folks, 1.5, 1 1/3, 1 2/3 glasses of wine over that period of time with a full meal is not enough alcohol to make a person impaired. This was not a big night of drinking. This was a business dinner with his boss after he'd been there for the day, with his wife, his boss's wife, and some guests of theirs from San Antonio. And here they are, sitting around the table. And you can see he had a full meal. Everybody had plenty to eat that night. Some ordered appetizers, some ordered full-size dishes. Okay? Let's talk about DUI less safe. Okay? Ms. Batras went to great lengths to make sure you understood that he's not being charged with being over the legal limit. And I submit to you that there's a reason why he's not charged with being over the legal limits, because there's no evidence he was over the legal limit. So they can only charge him with being less safe. And she outlined for you, and the judge will outline for you. But there's one part of this instruction. This is a legal instruction that Judge Besson's going to give you when we're done giving our closing arguments. There's one part of that she didn't tell you. And that's merely showing that the defendant had been drinking or that there was the smell of alcohol in the defendant's breath or person without proof of the manner of driving or the ability to drive is insufficient to prove that the defendant was guilty of driving under the influence of alcohol. And I'll ask you to listen for this next statement from Judge Besson. Don't take it from me, take it from the judge instructing on the law. It is not a violation of the law to simply consume alcohol and drive a vehicle, and operate a motor vehicle. Folks, we're not a zero-tolerance state. There are European countries that have a lower legal limit than we do. In our history, we've had higher legal limits than we have now. But it has never been the law of this state, and it is not the law on August 28, 2013, that a person cannot have a glass or two of wine at dinner as long as they're not driving in an impaired manner. That's not a violation of the law. Please listen for that. When you get back to the jury room, I'm going to talk about reasonable doubt in just a moment. Here's what I want to tell you. And let me set this down for a minute. Let me ask you to do this. I'm not going to tell you how to do your deliberations. I just want to ask you if you will consider my suggestion about how you might consider deliberating. You all decide, but here's my suggestion. I'm going to go through what I find to be reasons for doubt in the case. You may disagree with some of my reasons. You may agree with some of my reasons. What I might suggest to you is this, considering this, that the judge will instruct you that what your role today is to determine if the state proved each and every element of the case on each charge beyond a reasonable doubt. That it might be helpful before you say, what does everybody think, guilty, not guilty, to maybe just, because I've seen some of you writing things down throughout the trial, and I appreciate that, maybe to talk about what are some reasons for doubt that you might have. What are some reasons for doubt that you might have? Your reasons for doubt might be different than one of your other jurors. Certainly your reasons for doubt may be different than mine. But in applying the legal standard, and I'll talk about this in a moment also, what the police officer does on the road is to determine if there's probable cause to arrest someone. What you're being asked to do is to determine if they prove their case beyond a reasonable doubt. And there's a difference that I'll go over in just a minute. But I want you to consider that. You folks deliberate however you think, however suits you. But just a suggestion from me that I hope you'll consider, that before you begin talking about what your verdict is, perhaps you would go around the room and say, well, here are my reasons for doubt. I heard this, or I didn't hear this. And consider that there may be reasons that you didn't think of that some of your fellow jurors may have. So I hope you'll consider that. Okay. Let's look at actual driving ability. Because you'll also be instructed that one of the things that you're to look at is, what is the driving ability of the defendant? And this is interesting to me. This is a direct quote from Trooper Nelm's testimony. He did get especially close to that curb, and I'm glad he didn't hit it, because it probably would have tore his car all to pieces. So he avoided that by just a couple inches, which really don't mean anything, but it does stand out a little. Why is he getting this close to a curb in a car that was actually an Audi A8? Now, there's a video and evidence, there's some photographs and evidence, and I've taken clips of them. That may be hard to see, but I'm going to ask you if you can look where his front tire is. And I hope you'll agree with me that his front tire is about to touch the first white line in the crosswalk. You see that? It's not the greatest picture. Oh, I'm sorry. And then, go back one. There's his turn. He is about to touch the white line. There's his turn there. His front tire is over the white line, and his rear tire is out here, about to touch the white line also. And then I want you to look at what we have in evidence. Take a look at where that white line is. I'm sorry I'm not getting fits from my... okay. There. Look at the distance between the white line and the actual curb. Look at that distance. Is that a matter of inches? Look at it up close. Look at it one more time. Look at this distance from the curb to here that Trooper Nelms tried to sell you. I'm comfortable using that word. He tried to sell you that there was a traffic violation when there was not. And I said to him, isn't that what we want our drivers to do? We want them when they drive to be close to the yellow line but not go over it. We want them to be close to the curb but not touch it. I submit to you that what Trooper Nelms did from this stand was to try and improve the evidence in this case that was gathered on that night that wasn't in his report, wasn't previously testified to, and frankly, it was made up and exaggerated. That's what happened here. I'm going to go through you and I'm going to show you exactly where. What is the state's burden of proof? Remember what I mentioned a moment ago? All right, let's go over this together real quick. No evidence. The state has no authority to stop you. Right? They got to leave you alone unless they have some evidence they don't want to commit a crime. A reasonable suspicion. That's what a police officer has to have on the roadside to stop your vehicle. He reasonably suspects you may have committed a traffic violation. In this case, having your headlights out, right? Clearly he had reasonable suspicion to stop him for the headlights out. Probable cause is the next highest burden of proof. Probable cause is enough to arrest you, right? Enough to take you off the street, cuff you, jail you, put you behind bars. Okay, that's still not proof beyond a reasonable doubt. The next level of proof in our justice system is a preponderance of the evidence. Preponderance means more than not. Preponderance is this: enough to tip the scales in favor of one side or the other. In a civil case, somebody didn't do a renovation on a house, a suit on a contract, anything for money essentially, any lawsuit for money. One party has to show 50% plus one, a preponderance of the evidence in their favor, and they can recover money damages. That's in a civil case. This is a criminal case. Clear and convincing evidence is the next highest burden of proof in the justice system. Here's a good example of clear and convincing evidence. In a parental termination suit, the state must show that there's clear and convincing evidence that the parent is unfit. So the way I would describe that is, that amount of evidence is enough to permanently take away your child. Enough to permanently take away parental rights over a child. For whatever reason, there has to be clear and convincing evidence. That's got to be a very high burden of proof to do permanently take away a person's child. But that's still not proof beyond a reasonable doubt. Proof beyond a reasonable doubt, the way our founding fathers set this up is, it is the highest burden of proof in the criminal justice system. Okay? Beyond a reasonable doubt means what it sounds like, that there is no reason to doubt left. Okay? And beyond a reasonable doubt, I submit to you, in a DUI and a taillight case, is the exact same level of proof in a rape case, in an armed robbery case, in a murder case, any felony case. It's the same level of proof. Judge Besson will tell you, and again, listen for her instructions. It's going to be a long instruction she's going to give you. That reasonable doubt, part of it is defined this way. If your mind is wavering, unsettled, or unsatisfied, that is the doubt of the law, and you must acquit the defendant. So I want to ask you this question. Let's think about the two charges. Driving without taillights on. DUI. Okay? How do you feel? Let me just ask you for a moment. How do you feel about the level of evidence that the state has presented on the driving without taillights charge? How do you feel about it? I feel pretty good on video. I would not blame you for a moment if you said, you know what, there's enough evidence for me beyond a reasonable doubt. I think we find him guilty of that charge. Now I'm going to ask you this. How do you feel when you think about how you felt about that charge? How do you feel about the level of evidence on the DUI charge? How do you feel about it? Was there any drop-off between how you feel about the taillight charge and how you feel about the DUI charge? If there's any drop-off, well, I'm not so sure. We didn't know all about that stuff, about the doctor and the waiter and Danny Ferry coming in and all the other witnesses the defense presented. We didn't know about this repeated request to get a test after he was booked into the jail. If there's any drop-off between how you feel about that taillight charge and how you feel about the DUI charge, if your mind is wavering, unsettled, or unsatisfied, that is the doubt of the law. You must acquit the defendant. That will be the instruction from Judge Besson. So, what is a reasonable doubt? What is the law defined as a reasonable doubt? And again, I'll ask you to listen for this. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. Reasonable doubt can arise from the evidence. It can arise from a lack of evidence. It can arise from a conflict in the evidence. I'd like to go through with you briefly each of those principles and what the evidence has been, what the lack of evidence has been, and what the conflicts in the evidence are. How am I doing on time?
19 minutes. 18 minutes.
Thank you. Left. This is a little smaller than I would have hoped for. I did, and I don't mind telling you this. I usually use whiteboards. I'm using PowerPoint in this case. I'm doing my best to try and present this to you. If it's not working perfectly, forgive me. But evidence of actual impaired driving. The only thing that they have, and the only thing that they can characterize is he should have known that his headlights were on. Okay? But there are no traffic violations. Despite the trooper nouns came in here and tried to sell you on that there were traffic violations, there are none. Only an equipment violation. And the equipment violation is that his lights were turned off, or that they just weren't working. I submit to you they were turned off. Who brought you that evidence? Adrian Hernandez, the valet supervisor, testified, no, we don't keep a record of exactly who valeted the car. But I'll ask you folks this, does it make sense to you? Did you think Mr. Hernandez was untruthful about anything he said? He was pretty much a fact witness that described for us. And the prosecutor says, well, they think somebody probably might have turned off his lights. Remember the word he used? It's their policy. Their policy is if you have automatic lights, they're going to turn it off, and why? Because they don't want to get a situation where they're having to open somebody's hood up and jump their car off and there could be liability. Right or wrong, it's their policy, and that's what happened. It's unrebutted testimony that Coach Budenholzer was staying at the Lowe's Hotel, that he testified unrebutted that he parked his car there that night after his day at work, that the next morning when the sun was shining he picked it up, he dropped it off early afternoon while the sun was still shining, and didn't come back to his car until the sun was down in a well-lit parking lot, and drove through an exceptionally well-lit area down one exit to 10th Street to get off when he was stopped. Red and glassy eyes. I'm not going to spend a lot of time on this, okay? If this were a situation where after these events occurred that we sent Mr. Budenholzer to some ophthalmologist to come and tell you that he had an eye condition, to come tell you that he had natural nystagmus in his eyes, I'd be very suspect of that evidence. But what you learned is he's been treating him since 2003. That he has this condition, and Bud told you, if there's anything you learn from Bud is he's not a very good patient. He didn't like taking the drops. He didn't clean his eyes like he was supposed to. It's a condition that he lives with. It's a condition that his eyes are pretty well red all the time. And you know, the prosecutor went and pulled a couple of images off Google that showed his eyes weren't that red. You know, you can pick and choose which ones you want, okay? And what did Bud tell us? Some days are better than others, right? There's one that's a little bit better than the other. There's one not so good, right? Let me ask you this. See all these photos? See the ones the state brought in? What do trooper nouns tell us is the first thing that happens when a person's taken to jail? They're booked in. What does book in mean? They're fingerprinted and photographed. In fact, he used the term they photograph their eyes when they come to the jail. Where is that photograph? Where is the photograph that the state had custody and control of that was taken at the jail to show you exactly what his eyes looked like that night? We could spend all our time in court saying, well, I can find these pictures that show his eyes are red, and we can find pictures that show his eyes are white, and I can show you Mr. Budenholzer sitting right here in court in front of me, and you can see for yourself, and you saw him on the stand. And folks, judge for yourself. Judge for yourself whether you think red and glassy eyes are a part of this man's medical condition that he has to live with, or is it what Trooper Nelms thought? Trooper Nelms said, I thought this was just a guy was stopping because his headlights were off. And Ms. Botcher said, well, how did it turn into a DUI investigation? And you know what his answer was? I saw that he had red and glassy eyes. And Coach admitted he had had a glass of wine. He admitted under oath to you that he had a glass and a half or so of wine. But that's not enough to make him impaired. That's not enough to impair his ability to drive. We'll do it clear. Right here. The next thing that we learned is particularly interesting. We learned from Dr. Rashid, not only does he have this condition, blepharoconjunctivitis, which makes his eyes red, but he is one of that percentage of the population that has natural nystagmus. Okay? Nystagmus, remember, is an involuntary jerking of the eyes. We learned that alcohol is one of the things that can cause it to be more visible. And the doctor acknowledged, yes, in some people, if you add alcohol to that, can cause it to be more visible. But the one thing that remains unrebutted is that Trooper Nelms made his decision to arrest partially based on the horizontal gaze nystagmus eye test. And he did not take into account that there was also possibly a medical condition that caused that to happen even in the absence of any alcohol. So, it's like asking somebody with a prosthetic leg to do a walk and turn test. Mr. Budenholzer was not a good candidate to submit to an eye test because we learned. And again, it's unrebutted. They didn't bring in an expert to tell you, no, he doesn't have that condition. His doctor of 13 years, again, this is not somebody that was hired since these events occurred. His doctor of 13 years told you he has naturally occurring horizontal gaze nystagmus. Lastly, from the evidence, there's one more slide on this. The sleepy waiter, I left it fly out. The dinner receipt, you saw it for yourself. Nobody had an excessive amount of alcohol. I'm trained to observe if they did. The men had wine, the ladies had champagne, the young man a beer. It's important we serve just 6 ounces of wine. So, think about what 6 ounces of wine is. Think about a 12-ounce beer, right? Regular beer. Half of that is a standard pour, 6 ounces of wine. Vertical gaze nystagmus. Let's talk about what the evidence was. The prosecutor asked the police officer what tests did he rely on to make the arrest. What did she leave out? She left out a test that suggested that he was not impaired by alcohol. And until I got up and had the opportunity to question him, and he had to acknowledge that because you saw it on videotape, you would not have known about it. What did we learn the importance of vertical gaze nystagmus is? If there is no presence of vertical gaze nystagmus, what does it mean? These are his words. It is not a high dose of alcohol for that individual. Positive evidence that whatever alcohol Mr. Budenholzer may have had, it was not impairing his ability to drive. Okay? I can't emphasize that enough. And I think that it's valuable for you to consider that the judge will tell you, as I said, that reasonable doubt is the doubt of a fair and impartial juror honestly seeking the truth. The truth here had to be brought out by the defense to show you that there were tests that showed that he was not impaired by alcohol. Clear speech. I'm going to get to this in a few minutes. I've got a few slides on this. It's not mumbled. It's not slow. It's not slurred. And I'll ask you to compare what you heard on the stand. Little things. He was able to instruct Officer Nelms on how to open up his phone, what his items were that he was concerned about in his car, his iPad. And then we all went over this. And I'm going to go over this one more time. I'm not going to say it again. He arrived at 11:40 p.m. Mr. Ferry looked at the cell phone records. When he learned what had happened, what was his response? Bud, you're not drunk. Take the thing test. Okay? Budenholzer repeatedly at that point asked for a breath and blood test. At 11:49, he'd been at the jail for about 9 minutes. We know Trooper Nelms was still at the jail somewhere until 12:13. What else did we know? He had a blood test kit with him. It was in his car. And there was a nurse on duty. Let's talk about the lack of evidence. No test was ever given. No blood search warrant was ever requested. Why? He was new. He wasn't in the system. Could have asked another trooper to assist him. We're going to talk about that in a minute. He didn't request any assistance from his fellow troopers. No request for guidance from his supervisors. And perhaps most importantly, he never asked for a blood test. Nelms never asked if Budenholzer would submit to a blood test. Budenholzer told you from the stand he's never been told not to submit to a blood test, only a breath test. And we talked about no traffic violations committed. Here's a question. Where are the other witnesses that the state could have called? We learned that there are a trooper Pyland who signed as a witness the Miranda form. There was another trooper at the jail. We learned that he spoke with Sergeant Cronin and Corporal Land. They were not called to the stand in this trial. We learned there was a Captain Hinton and an Officer Lawrence. Who called Officer Hinton? Who called Captain Hinton? Was it the state or was it the defense? Why did not the state call Captain Hinton? Conflict in the evidence. The traffic violations. No citation was offered for this newly created traffic violation. After testifying, Nelms saw no traffic violations when I questioned him, and then all of a sudden he did. Nelms did not want to acknowledge that Mr. Budenholzer handed him his driver's license with no problem. We learned that they're trained to look for these things, but Trooper Nelms said, I don't follow my training in that regard. Most importantly, I'm going to ask you to make your own assessment of what you hear if speech is slow, mumbled, and slurred. We'll get to that in just a moment. Walking to the rear of the car, it's not on the report, but Nelms made a mental note. He walked perfectly fine to the back of the car. Nelms added a clue in court. Added a clue for the first time in court to the walk and turn test. Nelms' field sobriety training, he had 24 hours in a class. He was given the opportunity to practice. He was told what would be on the exam. Budenholzer, never given the opportunity to practice. Not told, if you put your arms out, that I'm going to mark a point against you. And he never put his foot down on a one-leg stand. Bear that in mind. And then lastly, I'm not going to spend a lot of time on this. Where does your mind tell you? Are we dealing with a man who is an athlete, like the prosecutor's trying to make him up to be? He was good enough to play basketball in Division III. He was good enough to play 1 year in Denmark. His life has been spent as a coach. If you believe he's an athlete, there's not much I can do to dissuade you of that. He's also 44 years old at the time. I'm 48 years old. I promise you I'm not nearly as good at being athletic as I was in my 20s. And I suspect you've had a similar experience. Let's talk about a major conflict in the evidence. Why is it important to consider the police officer did not give Mr. Budenholzer the chance to have a blood or a breath test? Judge is going to tell you that he refused. There's no doubt on it. It's on video. He said, I don't want to take the breath test. Okay? But look at what also happened. Each time he was asked to take a breath test, he asked if he could consult with someone, and the police officer told him no. The one time he did have the chance to consult with someone, what happened next? He immediately undertook to start asking to take a test. Here's a couple of quotes. And guys, I know this has been a long time, but if you could do your best to try and keep your eyes open and pay attention to this, I'd be very grateful. Let's go to the questions. This is from the transcript from the trial. What time did you arrive at the jail? Do you recall approximately? I don't recall. It was probably about 30 minutes after I put him in the back seat of the car. It probably would have been around 11:40. Next slide. Just note this. He said, we looked at your unit history. You actually left the jail at 12:13 a.m. He acknowledged and he thinks that that's right. And then this is important. There's two slides I want you to look at here that I didn't quite catch during his testimony. This is when Ms. Batress is asking him about going back with the blood kit. Look what he says. He says, I could be taking a blood test down to somebody else that maybe needed one, but I did come in with one that evening. I did have one present with me, and no, I did not decide to use the blood test. I wasn't planning on using the blood test unless one of my supervisors there, if I made contact with them because there was something wrong and they told me to get a blood test, that would have been the only time I would have done that. And I didn't see no need to contact my supervisors for any odd reason on what was already there that I could handle. Nelms didn't need to ask his supervisors for help. He's been on the job for 3.5 weeks, and he unilaterally decided not to contact his supervisors to determine what to do. Why? Next. Nelms didn't know how to get a blood test. What if Nelms had allowed him to take the breath test, and then he told you he would have had to have given him that blood test? But here's what he says. I was a little bit unfamiliar with how they would go about obtaining a blood test, whether it be at a local hospital or what. I was trying to cut down the time to go to the place. I never knew where I needed to go. He didn't know where to get a blood test. More conflicts in the evidence. Who did you find more difficult to understand when they were talking? Trooper Nelms or Mr. Budenholzer? I'm not picking on Nelms because he comes from the country. But there are times when I found him particularly difficult to understand. And Mr. Budenholzer's speech is clear. 4 minutes. What does Trooper Nelms say about his speech? It was mumbled, slurred, and slow. Let's play that clip for him, can we? Let's listen to Budenholzer's speech, please. Just turn it up as best you can. Is it coming through there? Mm-hmm. It's okay.
Contact in the middle, actually, if you see where it says Mary Beth, right there in red, maybe that one.
Hold on.
Do you have that number where I can give her Danny's number?
Judge, could you turn this mic on for me briefly?
Hey, Mary Beth. No, I've been pulled over for DUI. don't think I had a glass of wine with Danny and Tiffany. But, I tried to call 15 if you weren't answering. Okay. Yeah, so just, I don't think I'll have my cell phone on me in the Atlanta pretrial jail. Atlanta pretrial jail. Okay. You'll be okay, Denise. Take time. Don't be nervous and you'll be fine. It's hard not to be nervous, but I'm sure I'll be fine. Thank you. You'll be fine, honey. I love you. All right, I love you. Okay. All right, I love
It's
you.
hard not to be nervous, but I'm sure I'll be fine.
Thank you.
So just a real quick contrast and I'll conclude. Mr. Budenholzer asked repeatedly when he wasn't sure what to do for help. He asked for help from the trooper to contact someone who could help him answer the question what his rights and obligations were about taking this breath test. He was repeatedly denied. Is there anything wrong in your mind with a person faced with an important legal decision asking for help with someone who might know better? You learned he's never been through this before. He's never been charged with DUI. He's never been asked to do field sobriety tests. Contrast that with Trooper Nellens. 3 weeks on the job, 3.5 weeks. Unilaterally decides he's not going to contact his supervisors. We learned that there were other troopers down at the jail. One of them signed off on this form, and he testified that he was in a room where another trooper was giving a breath test. But he did not want to get a blood search warrant because he said words to the effect, I didn't want to bring somebody else into the case. This is a brand new trooper, for whatever reason, is making decisions on his own without consulting. And there's nothing wrong with asking for help. And ladies and gentlemen, I need to do this. Mike Budenholzer now needs your help. The state has not met their burden of proof beyond a reasonable doubt. Again, get back to how do you feel about the taillight? How do you feel about the DUI charge? If there's any trailing off, that's the doubt of the law. If your mind is wavering, unsettled, or unsatisfied, I'll ask you to find him not guilty of the DUI charge. Please hold that burden of proof very seriously. This is a very important decision for Mr. Budenholzer. And I ask you to hold the state to their burden of proof and find that they did not meet their burden by proving the DUI charge beyond a reasonable doubt. And I'll ask you to render a verdict of not guilty on that charge. Thank you.
Yes, Your Honor. Let me just have a moment to... Some days are worse than others. You heard Mr. Hawkins say it. He was talking about Mr. Budenholzer's eyes, but the truth is, some days are worse than others, and this was a particularly bad day for Mr. Budenholzer. Now, let me start with the elephant in the room, if you will. So much talk about the state presenting one evidence only. The judge will instruct you that one witness's testimony is sufficient if you feel that establishes the elements of the crime. And the state has provided for you not just that witness's testimony, but we have also provided the video for you to see for yourself. It speaks for itself. And Mr. Budenholzer, as a bonus, also came in and said the reason he stumbled did not have to do with the injury to his foot. It did not have to do with dizziness from holding the pen out too far. None of the arguments that they made about what caused that lack of balance, what caused that impairment in being able to walk forward, which therefore translates into impairment when doing another divided attention task, which is driving a car through the streets of Atlanta. We have established that. You'll notice on that timeline they had, the one section they didn't have a little bubble for, between 10:10 or 10:30 and 10:43, was those field sobriety tests that are in that video that you saw for yourself. There's a lot of stuff going on here, a lot of distractions. It's sort of like if you ever as a child, or have for your children, gotten a snow globe. Everybody's seen a snow globe before, right? Lots of distractions. Shiny distractions. Most snow globes I ever had, I couldn't even tell you what was on the inside of them because I spent so much time watching the snow and the glitter float around. And that's what you're being presented, ladies and gentlemen, snow and glitter. Glittery witnesses being flown in from all over the country to testify to what? Nothing. None of them could remember anything significant. None of them were there with him when he took those field sobriety tests. Glitter. Name dropping. I must have heard at least 4 names of NBA teams in here. Glitter. Oh, he wanted a blood test. When was that? 2.5 hours later. 2.5 hours later. Glitter. Pay attention to the relevant time period here. The time period that they avoided talking about until the very last section in there. But can they come up with, did they establish that we had proved the impairment? No. Ladies and gentlemen, we established that impairment in the video. We showed Michael Budenholzer impaired by the alcohol. The alcohol he lied about, forgot about, misinterpreted. We showed that he refused to take a test. You're right, he's right. It is absolutely not illegal to have alcohol and drive. You just cannot be impaired to the extent that you are less safe. And on that night, on a glass and a half at least of wine, he demonstrated he was impaired. He was less safe. Don't be fooled by the glitter. Don't be fooled by 17 witnesses. More is not always better. More is sometimes just more. It's a distraction. It's a distraction from the evidence that the trooper gave about his training and how he determined impairment. It's a distraction from what you see in the video in those field sobriety tests at the relevant time that this case was being assessed. We are not here to prove he was impaired 2.5 hours later. We are not here to prove he was impaired at 9 o'clock when you met with Mr. Ferry. We are here to establish that at approximately 10:15, when he was seen driving without his taillights, Mr. Budenholzer was impaired by the alcohol in his system to the extent he was a less safe driver than he would have been without that alcohol in the system. Do not be fooled by the glitter. That's what they want. Remember what's important. The thing that they don't talk about is right here. In that test, every time Mr. Budenholzer lost his balance, every time that he stepped offline, used his arms for balance, that was an indicator that he would have been a less safe driver. And to find him, to acquit him of these charges would be to say that he should have gotten his keys back in his hand and driven away. And ladies and gentlemen, the state, I proffer to you, has established that that's the picture you need to remember. And find him guilty on both counts. Thank you.
That's just, I've got a lot that I have to read you. Does anyone need a restroom break before I start? Okay. And I just need this cord, please. Yes.
If it's,
I do not have the right. I don't think they do.
oh, sorry.
It's okay to be on.
What? No, it's just supposed to come on. So is this not switching screens?
You want to do it on the projector? You just hook up to my projector, and or you can use my laptop. Just put it on a thumb drive. And
Yeah.
which do you prefer?
Whoever was using this, and this is still plugged in. Will you just make sure this is plugged in all the way? And then it'd be this one. Yeah, it is. I mean, if I put it on drive, but I have to read it from here. It's not that one, it's, it should be this one.
HDMI 3.
It's one, is it in three?
There's a DVD in. Well, okay, I'm sorry. You should be on DVI 1.
Yeah.
HDMI
I'm
one.
sorry. I'm sorry. It says DVD.
You're welcome to try my laptop. I don't know if that's any.
Yeah, I may have to, for some reason it's not, keep saying it's on PC only, and it's not going to the other screen.
You have it on the flash and try.
All right, well, let's get it on a, drive, I mean, 'cause I have to read it from here, otherwise it's not,
Do you want to at least to see if it,
yeah, let's see if it'll work for yours.
just put it on a, do you mind if that shows when? I think it's
And
time
then
now.
I'll just put it on a drive onto yours. No, because, oh, is it HDMI?
No, this would be the HDMI. I'm going to try and stick that directly into the.
Well, maybe it is this. Let's try sticking that in without this. Yeah.
So you can, if you need to put this on, and you can just see it when it's ready, Your Honor.
We just download this to this. And that way it's kind of set plug essential kind of open here.
Just let me know if you use one, probably. Oh, you can take out that little one too.
Yeah, just,
I think I just left the HDMI on there.
have a,
There should be PowerPoint open, hopefully. If not, you should just be able to click on it. It should open.
were you in PowerPoint?
I was, Your Honor. Might say it on the bottom.
All right, but I need to find this. I'll let you do this because I'm trying to find your.
I understand. Flash drive.
Yeah. I think it's LTS. Did you find it? And I just need to forward now.
It's this one, and it's up here in the front. Thank you. Next to that small thing. In front of the small one. There we go.
Here we go. These are the jury instructions for the state of Georgia versus Michael Budenholzer, case number 15CR005624. You have been considering this the case of the state of Georgia versus Michael Budenholzer. The defendant has been charged with the offenses as follows. I'm going to read them to you again. I, Carmen D. Smith, Solicitor General for the County of Fulton, State of Georgia, in the name and behalf of the citizens of Georgia, do hereby charge and accuse Michael Vincent Budenholzer with the offense of defective or no taillights, a misdemeanor, or that said accused in the County of Fulton, State of Georgia, did on or about August 28, 2013, operate a motor vehicle without properly working taillights in violation of OCGA Section 40-8-23, contrary to the laws of this state, the good order, peace, and dignity thereof. Additionally, I, Carmen D. Smith, Solicitor General for the County of Fulton, State of Georgia, in the name and behalf of the citizens of Georgia, do hereby charge and accuse Michael Budenholzer with the offense of DUI, driving under the influence of alcohol less safe, a misdemeanor, or that said accused in the County of Fulton, State of Georgia, did on or about August 28, 2013, drive a moving vehicle while under the influence of alcohol to the extent that it was less safe for such a person to drive in violation of OCGA Section 40-6-391A1, contrary to the laws of this state, the good order, peace, and dignity thereof. Signed, Carmen D. Smith, Solicitor General. To these charges, the defendant has entered a plea of not guilty, and the accusation and the plea form the issue that you will decide today. Neither the accusation nor the plea of not guilty should be considered as evidence. So let me just tell you also that I'm going to read these, and obviously you can follow along as I read them. You are welcome to take whatever notes you think are going to be helpful for you. You will not have a copy of these charges with you during your deliberations. But I just caution, sometimes people are so worried they're writing down everything I'm saying, but they're not hearing what I'm saying and they miss some of it. But certainly you can take whatever notes you feel are going to be helpful. Hold on 1 second. Okay, I'll make this brighter. I guess it isn't. Maybe that's it. Okay. Presumption of innocence, burden of proof. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in his or her favor. The presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses as charged. No person shall be convicted of any crime unless and until each element of the crime as charged has been proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the accusation and every essential element of the crime as charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his or her innocence. However, the state is not required to prove guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, any lack of evidence, or any conflicts in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you should acquit the defendant. However, if that doubt does not exist in your mind as to the guilt of the accused, then you'd be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Grave suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of defendant's guilt, are not sufficient to authorize a conviction of the defendant. Evidence. Your oath requires you to decide this case based upon the evidence. Evidence is a means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits that may have been admitted during the course of the trial. It does not include the accusations, the plea of not guilty, opening statements, closing arguments by the attorneys, or any questions asked by the attorneys. Direct and circumstantial evidence. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasonable and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is testimony of a person, such as an eyewitness, who may have personally observed the fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove other facts by way of inference. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. You are not, however, required to accept any alternative hypotheses offered by the defendant. Credibility of the witnesses. You, the jury, must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity for knowing the facts about which they testified, the probability or improbability of their testimony, and the occurrences about which they have testified. You may also consider their personal credibility insofar as you have observed it here in court. Testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Witness impeached. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. You may determine whether there was evidence that a witness testified falsely about a fact during the course of the trial as opposed to some other time before trial. In doing so, you may make a determination whether the misstatement was because of an innocent lapse in memory or an intentional attempt to deceive. You should consider all the facts and circumstances of any prior statements. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think that they are properly entitled to receive. Definition of a crime. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent. Intent is the essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proving facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter totally within your discretion. Intent for driving under the influence. To prove DUI, the state would not need to prove that the defendant intended the offense of driving under the influence, but the state must prove the defendant's condition of being under the influence of alcohol to the extent of impairment, and while in this condition, the intent to drive. The general intent may or may not be inferred from the conduct of the accused and other circumstances. Driving under the influence less safe. It shall be unlawful for any person while under the influence of alcohol to drive or be in actual physical control of any moving vehicle anywhere within this state. A driver or operator of a motor vehicle is under the influence of alcohol when the person is affected by alcohol to the extent that it is less safe for the person to drive than it would be if the person were not affected by alcohol. A driver who is less safe is less efficient, less skillful, less coherent, less able, less qualified, less proficient. Each of these words conveys the same message that the driver must be so affected by the intoxicant that it adversely affected his or her operation of the motor vehicle. In deciding this issue, you may consider anything in the evidence that you find relevant in deciding whether the defendant was a less safe driver. Specifically, as to the consumption of alcohol, you may consider, among other factors, the smell or lack of smell of alcoholic beverages on the defendant's breath and or his or her person, and whether any test indicated the presence of alcohol in the defendant's system. As to whether the defendant was less safe to drive, you may consider the factors that you deem relevant, including but not limited to the actual manner of driving the motor vehicle, any traffic violations, the defendant's control of his or her mental and or physical abilities, the defendant's demeanor, the physical condition of the defendant, and any expert testimony. merely showing that the defendant had been drinking or that there was the smell of alcohol on the defendant's breath or person without proof of the manner of driving or the ability to drive is insufficient to prove that the defendant was guilty of driving under the influence of alcohol. It is not a violation of the law to simply consume alcohol and operate a motor vehicle. A witness who satisfactorily shows that he had the opportunity to observe and did observe the condition of another may testify as to whether that person was under the influence and the extent thereof, stating the facts upon which that opinion is based. A witness may testify as to whether the defendant was under the influence of alcohol and whether because of such intoxication the defendant was a less safe driver. Not necessary to be drunk. I charge you that it is not necessary for the state to show that the accused was drunk. It is sufficient if the state shows beyond a reasonable doubt that the accused was under the influence of alcohol to the extent that it was less safe for him or her to drive a motor vehicle than it would have been if he or she had not consumed the alcohol, drunk or not. Less safe manner. A person who is charged with driving under the influence does not have to be observed actually operating his motor vehicle in a less safe manner, since that fact would be immaterial to the existence of probable cause for the arrest. There is no requirement that the person actually commit an unsafe act. Horizontal gaze nystagmus, or HGN test, is based on well-known and medically accepted principles. Nystagmus, which may be naturally occurring, can also be caused by ingestion of alcohol. The HGN test is an acceptable procedure that has reached a state of verifiable certainty in the scientific community and is admissible as a basis upon which an officer can determine whether a driver was impaired by alcohol. If the state has shown that the officer substantially performed the scientific procedure in an acceptable manner, the burden to show any error then shifts to the defendant. The weight given to this, like any other evaluations, is a matter for you to decide. Refusal and implied consent. Any person who operates a motor vehicle upon the highways or elsewhere throughout this state shall be deemed to have given consent subject to the police officer's compliance with the laws of this state to a chemical test or tests of one's blood, breath, urine, or other bodily substances for the purpose of determining the presence of alcohol or any other drug if arrested for any offense arising out of acts alleged to have been committed in violation of this state's laws concerning driving under the influence of alcohol. The test or tests shall be administered at the request of a law enforcement officer who has reasonable grounds to believe that the person has been driving or was in actual physical control of a moving motor vehicle upon the highways or elsewhere throughout this state in violation of Georgia's driving under the influence of alcohol laws. The requesting officer shall designate which test or tests shall be administered. It is not the right of the defendant to demand a particular test. However, the defendant can request his own test after taking the test requested by the officer. A person suspected of driving under the influence is not entitled to the advice of counsel when confronted with a decision as to whether or not to submit to a sobriety test under the implied consent law. Refusal and inference. A person accused of driving under the influence of alcohol to the extent that he or she was less safe has the right to refuse to submit to field sobriety exercises, a preliminary breath test, or any chemical tests requested by the law enforcement officer. The court has determined as a matter of law that the defendant refused the state-administered test. Evidence about defendant's later requests to submit to a test have only been admitted to demonstrate his condition or state of mind after the arrest. Because defendant refused to take the state-requested chemical test, you may infer that the test or tests would have shown the presence of alcohol, though not that the alcohol impaired his or her driving ability. This inference may be rebutted, and this inference alone is insufficient to convict the defendant. Nothing in the DUI statute shall be deemed to preclude the acquisition or admission of evidence of a violation of the DUI statutes if obtained by voluntary consent or a search warrant as authorized by the U.S. Constitution or the laws of this state. Demeanor of defendant. In a DUI case in which chemical test evidence is not available, a defendant's demeanor can be telling. Whether or not a chemical test evidence is or is not available is a question of fact for you, the jury. Evidence concerning the demeanor and behavior of a person charged with driving under the influence may be evaluated by you, the jury, as a factor to aid in determining whether a defendant was under the influence of alcohol and was therefore a less safe driver. Tailgate requirement. Any person who operates a motor vehicle without properly working taillights is in violation of the offense of defective or no taillights. Anyone violating any part of Chapter 6 of Title 40, the Uniform Rules of the Road, or Chapter 8 of Title 40 relating to equipment and inspection of motor vehicles has violated as strict liability statute. This means that although the state must prove that the accused intended to do the acts or to make the omissions that are prohibited, the state does not have to prove mental fault. Therefore, the state will have met its burden of proof as to defendant's criminal intent if you should find beyond a reasonable doubt that the defendant intended to operate his vehicle at a time that the vehicle had either no taillights or a defective taillight. The state does not have to prove that the defendant intended to be driving with defective or no taillights, or even that he knew he was doing so. Verdict. So you will have the verdict form in there with you. It's going to look just like this. There are two questions for you. We, the jury, find for the defendant either not guilty or guilty of the offense of failure to have taillights illuminated. Number two, we, the jury, find the defendant either not guilty or guilty of the offense of DUI less safe. And you'll circle whichever you collectively agree to. Unanimous verdict. Whatever your verdict is, it must be unanimous. That means it must be agreed to by all of you. The verdict must be in writing and signed by one of you who you select to act as the foreperson, and then it should be dated and returned or read here in open court. Sentencing. You are only to be concerned with the guilt or innocence of the defendant. You need not concern yourselves with any possible punishment the court might impose. Court has no interest in this case. By no ruling or any comment that the court might have made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon any of the evidence, or upon the guilt or innocence of the defendant. These matters are solely for you, the jury, to decide based upon the evidence and these instructions. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor, affection, or partiality to any party. It is your duty to consider the facts of this case objectively without favor, affection, or sympathy to any party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, religion, or one's economic status. All persons stand equal before the law. Deliberations. One of your first duties in the jury room will be to select one of you to act as the foreperson who will preside over the deliberation and who will sign the verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must first decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. All right. So that concludes the reading of the charge. We're going to get the evidence together in just a minute. Several things. Number one, you are to go in there and make a phone call, because then the deputy is going to take your phones and devices. You are not to have those while you begin deliberating. It is 3:30. Oh, let me just do that. It is 3:30. So what we'll do is we'll begin deliberating, and if we haven't heard from you by about 4:45, I'll send a deputy in to see where you're at. As I said to you, I will defer to whatever your pleasure is. If you'd like to stay a little later, you feel you're close, we'll do that. If you decide you're far apart and that's not going to happen and you want to go home for the evening, we'll do that as well. I have a verdict here for you. As I said, we're going to get the evidence together. Two more things. Please do not ask for anything that I haven't given you. So whatever evidence is going to be admitted, there could be 1,001 reasons why something may have been referred to during the course of the trial and it didn't get admitted. Don't ask me for it. I'm not going to give it to you. Number two, if you have a question, the foreperson should write the question down on a piece of paper, turn the light on, and then the deputy will bring the note to me and I will discuss it with the attorneys and see if it's something I can respond to. If you can continue deliberating, I suggest you do that, because sometimes it takes a little while for me to get the court reporter and everyone gathered back in here, because I can't respond to your question until I discuss it with everyone. So if you have a question, but you can continue deliberating on some other matters, I suggest you do that. Obviously, I'm not going to don't intend to keep you in there waiting, but sometimes it just may take a little while till we get everyone together and I can respond to the questions. Finally, again, I said we're going to take your devices. You're only to rely on the evidence you heard here in court and any documents that have been admitted or the DVD. So that's why we're going to take your devices. It would be improper to do any independent research, and frankly, you've got a job to do now. And so this is, we found, the best way to keep you from being distracted. So the sooner you get to sort of handle matters at hand, that's what you should be focused on at this time. I think that's all I've got. Let me go ahead and excuse all of them except for Miss Bryan and Miss Ramey. If you can remain seated here, please. Let me have everyone else step inside. All right, so Jerry? Miss Ramey, just have a seat. So you are our two alternates. Sometimes people are happy when I tell them that. Sometimes they're unhappy because they've sat through the trial. I have no idea if we'll get a verdict today. If we don't get a verdict today and the folks have to come back tomorrow, it is possible that someone, for any number of reasons, is not able to return and we might need you. But rather than having you remain here, what I generally do is, we have their cell numbers, is that right? Okay. So I'm going to let you go home, but you are still under the court's order not to do any independent research and not to talk about anyone, talk about the case with anyone, not to have any contact with any of the parties, witnesses, or attorneys. When I get a verdict, either I will call you or someone from my office and let you know you've been released. If you don't hear from anyone tonight, that means we're potentially coming back tomorrow. If I would suggest to go on with your normal business, go to work, whatever you do. If it turns out that we do find out that we need you, it'll probably be between 9 and 9:30, and we would call you to arrange for one of you to come in. But at this point, I'm just going to release you from having to remain here while they deliberate. But again, you are not supposed to do any independent research, not supposed to talk to anyone. It's as if you're still covered by all the same requirements. And then when we get a verdict tonight, either I'll call you or one of my staff members and let you know that you've been released. We'll let you know what the verdict is and so forth. So if you've got any belongings in there, you just escort them in so they don't discuss anything with them. Go ahead and do that. And then you both will be free to leave. I don't know. I believe you're retired now. I don't know if you needed something for work, but okay, you're good. Okay, because we could give you a letter. I mean, we'll send one anyway. But so definitely you'll take in to get your belongings, and then you're free to leave at this time and for further instruction from the court. And she'll hold on to your payouts. Let's go ahead and get them the evidence, and then I'll be happy to address any issues with the charges unless there's something immediate that I didn't do properly.